Hello everyone and welcome to today's Mondac webinar in association with RLM and Associates, covering the asset recovery landscape in Lebanon, what depositors of Lebanese banks should know. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Mohammed RLM is the founder and senior partner of RLM and Associates and focuses his practice on complex commercial, financial and investment cross-border advisory work. Mohammed is often requested to advise governments and state-owned enterprises on legislative reforms and regulatory developments as benchmarked to international best practices. He is a regular keynote speaker at international conferences on a multitude of current legal subjects. Nicholas Che chairs the international arbitration practice of RLM and Associates, which is headquartered in Abu Dhabi, the United Arab Emirates. An English barrister, he is also dual qualified as a French avocat and regularly appears as an advocate in arbitrations and related court proceedings. His experience as an international advocate and business diplomat has seen him represent governments, multinationals, banks and financial institutions. Rana Kawaji is a senior associate of RLM and Associates and focuses her practice on international dispute resolution and complex construction advisory work. She is often solicited to provide legal services and representation in dispute avoidance and resolution at all stages of the procedure. Her services are also sought on all construction-related matters with a client base that spans governments and states, energy and utility companies, lenders, developers and contractors. Mazen Ghone is an attorney, member of the dispute resolution group of RLM and Associates, based in the Beirut office. He deals primarily with international arbitration matters and has experience with disputes in a wide variety of industries, including aviation, franchising, distribution, energy, real estate, engineering construction, infrastructure, telecommunications, joint ventures, international sales, supply agreements, and financial services. Now, before I hand over to the panel, a housekeeping item. You can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage as many questions as possible. The panel will endeavour to answer as many questions as they can during the Q&A session, but please do reach out to them after the webinar for any additional information. It's now my pleasure to hand you over to our panel to begin. Thank you.
Well, thank you very much, Dan. It's been a pleasure to come here along with the team to provide a quick glimpse at probably one of the most discussed topic in Lebanon and for Lebanese in the diaspora, but also for global investors who had money in Lebanese banks. Some of them still do, or in other Lebanese financial instruments, as the case may be. So we will try today to give you a as much wide as possible view, of course at high level, of the recent developments, the legal positions, what is currently happening on this subject, and what would be certain, let's say, types of recommendations on the overall that may be stemming out of the actual experience of being in the Lebanese crisis for the last 3 years. Next slide, please. So very quickly, maybe Aaron, you can flip to the next slide. Thank you. So very quickly, as you know, Lebanon's economy for the last few years, I would say since the mid-50s and exacerbated in the 60s of the last century, has been a liberal regime with a specific focus on private initiative and guarantees. The private property of people, which is a very important and constitutional right. In fact, it is in the preamble of the Lebanese constitution that is consecrated that Lebanon's economic system is free and guarantees individual initiative and private property. This has been further enhanced in Articles 166 and 221 of what is called the Code of Obligations and Contracts, which is basically the civil code in Lebanon, which basically defines and makes sure that individuals may arrange their legal relationships as they wish, and of course sets agreements to be concluded according to regulations that are binding to the contracting parties, and of course the very famous principle in civil law jurisdictions, which is the interpretation and fulfillment of these obligations in good faith and in accordance with equity and practices. Next slide. Next slide, please. Okay, I think, yes, thank you. Now, Lebanon, as far as we can remember, at least our generation, has been a thriving place for banking, bank transactions, bank deposits. Banks in Lebanon have been extremely looked at as the backbone of the Lebanese economy. A lot of Lebanese in the diaspora trusted the system, and all of a sudden, something happened, and we are now going through a phase where Lebanon is enduring a severe and prolonged economic depression. According to the World Bank, the economic and financial crisis is likely to rank in the top 10, possibly the top 3 most severe crisis episodes globally since the mid-19th century. And the World Bank continues to say that in face of the colossal challenges, continuous policy inaction, and the absence of a fully functioning executive authority, this is threatening the already difficult socioeconomic conditions and a fragile social peace with no clear turning point in the horizon. Next slide, please. So basically, what is happening is that since October 17, 2019, which has led to an uprising all of a sudden, started basically on a simple decision to impose light tax on WhatsApp calls. And then, but obviously that was not the real cause. There has been a lot of causes. But what has happened quickly after that, those events, is that the government resigned. And this has thrown the country into a political chaos. Banks experience a sharp liquidity crunch, forcing them to declare some sort of a bank holiday and institute severe restrictions on bank withdrawals and transfers. Of course, capital inflows came to a sudden halt, as mostly a few months thereafter, we cannot say really that there is a functioning banking system in Lebanon as we speak. Next slide, please. Now, what would be the real causes of something like this? The real causes are basically mainly the fact that for a long time, public sector debt has been accumulating and has reached something close to $87 billion in October 2019. There were serious allegations of corruption, lack of governance on the political level. Lebanon has been ranked very low in the least corrupt nations, which meant that it is considered a place with a lot of corruption. Lebanese banks had lent a lot of their deposits, almost 3/4 of those deposits, to the government and the central bank. The Lebanese economy experienced basically very little or no growth at all for an entire decade. And there has been a prolonged political instability since the assassination of the late Prime Minister Hariri in 2005. On March 9, 2020, the Lebanese government decided to default on the repayment of a $1.2 billion Eurobond issuance, which was the first sovereign default in the country's history, despite the long civil war 1975 to 1991, where banking system was more or less functioning. Lebanon had not defaulted on any of its obligations, whether internally or externally. Now, as a result of these factors, what has happened effectively is that immediately this was felt. Please, the next slide. This was felt on the valuation of the Lebanese pound, which has started to a devaluation process till this day, which we will discuss. There was a creation of something called the Lollar, which is a abbreviation of the Lebanese dollar, which I will also explain. And of course, there has been dealings with multiple exchange rates of the dollar against the lira, which is the Lebanese pound. We will often refer to it as Lebanese lira because it is understood as such. And we now have maybe 4, 5, 6, 7 different rates of exchange, which is only exacerbating the depth of the financial crisis as it happens. Next slide, please. Now, on the devaluation of the Lebanese pound, very quickly, the Lebanese Central Bank has artificially pegged the Lebanese pound to a US dollar since 1997. That was meant to create some sort of stability for the Lebanese pound. Of course, there was a cost to that, but technically, if you ask around, everybody knows that for almost 24 years or 23 years, $1 used to trade at 1,500 lira. Now, to sustain the pegging, Lebanon Central Bank offered several incentives, including high interest rates to private banks, depositors, and investors on both the Lebanese lira and the US dollar when it needed liquidity. This has specifically led to a 2013 sharp increase in those interest levels. Again, in 2016, with what is best known as the financial re-engineering done by the central bank. In October 2019, the Lebanese pound had lost around 16% of its value, while till this day, the pegging of what we call the official dollar to the official lira by the central bank is still at 1,500. So currently, the Lebanese pound has lost around 95% of its value, and there is, of course, critical US dollar shortage triggering a parallel exchange rate in the local markets. Next slide, please. Now, very quickly, what has happened is that banks went to an unofficial, I would qualify it as illegal, capital control measures in the absence of an actual capital control law. This is a very important matter that needs to be understood, whereby unlike lots of countries that went through similar difficulties, immediately after the crisis, a capital control law is usually introduced to balance and put some equilibrium into the market. So you control the flow of foreign currency in and out. You have a better understanding of what's in there. You have the time to think. This has not happened in Lebanon. However, this has happened, let's say, ex officio, so unofficially. This was done, of course, with the blessing, let's say, even though silently, of the financial regulator. And therefore, as of the 2019, we saw first a 2-week complete shutdown on banking operations. Then there were slowly no more possibilities to withdraw US dollars in cash, even though this is a very common practice in Lebanon for the last tens of years, decades. There were also gradual restrictions on transferring foreign currency outside Lebanon, but also inside Lebanon. there were a very limited amounts of released cash US dollars in the market. Now recently you can't even trade with what is referred to as the Lollar that can be actually dealt with within interbank operations. Now, before we continue, maybe it is important that I explain, because this is an often asked question or a frequently asked question by lots of our let's say clients and friends and people wanting to know what's going on. What has happened is effectively that this denomination came from some financial analysts operating in Lebanon that immediately understood that you have dollars, real dollars, that are stuck within this Lebanese banking system. And these were identified as the dollars because they are not really dollars anymore, but they are some sort of a currency, and this will have legal repercussions once we go more into the legal side. And people started to actually use the term, so you can actually pay certain things at the time with dollars. Of course, this is not the case anymore because people, even though with time, started, but at the end, to understand exactly where this is going. So when we say Lollar, we mean previously US dollar to either October 2019, legally maybe April 2020, because there was a circular by the Banque du Liban at the time saying that every single dollar that was deposited in banks before April 2020, some sort of is called an old money. And now we're often referring to the real and the only US dollar as fresh US dollar. Of course, I don't like personally this expression, because as if there is something fresh and something that is not fresh, but we will discuss this more from a legal standpoint. Now, next slide, please. So very quickly on the market rates, while the pegging currently still stands at its old limits, today the real market rate, if you have $1, you can go and exchange this for 40,000 instead of 1,500. That's 26 times what we refer to as the official rate. There has been a creation of some sort of an unofficial, let's say, exchange platform called Sayrafa. Sayrafa was created officially in December 2021 by virtue of this Circular 161, where the central bank aimed to strengthen the fast evaluating currency by injecting actual dollars into the market. This has not really stopped the fall of the currency. Just for information, while the official rate is at 1,500, the real rate is around 40,000. Sayrafa rate today is around 30,000. Next page, please. Now, there is also something that is often referred to as the interbank rate or banking rate, which is 3,900 lira for the US dollar. Then there is another revised rate, which is 8,000 lira to the dollar. There has been some other circulars talking about the use of the Sayrafa and some other specific aspects like the 12,000 lira, which are all giving indications of the financial scenario that is being contemplated as we speak. Now, what we know just on the financial side is that Lebanon is planning to repeg the currency sometime soon. Of course, now we have some other things to take care of, like the transition to a new president of the republic, and therefore we're stalling a bit on the legislative side. So we will see how this would work, but we believe that this will change and it will have some effects as the case may be. Next slide, please. So very quickly, all of a sudden banks started adopting those random and restrictive regulations, including limits on daily and weekly withdrawals, reduction first on credit card limits, then there is no more credit cards and debit cards in the country, except in Lebanese lira. So if you had, if you were using frequently your US dollar account in Lebanon, which is completely allowed, and then all of a sudden you cannot use these credit cards, and you find yourself in a situation where you are denied access to your funds using your credit cards, locally and internationally. Now, cashing checks has been denied also, and of course, international transfers. So if I give somebody a check for $100, they cannot actually go to the bank and ask for it in dollars, which used to be a common practice in Lebanon. So you can take, of course, up to certain limits. You can cash in your checks. You can deal with cash. It has been part of our daily transaction. On the international transfers, this is even more something that has been in the essential part of being dealing with the Lebanese bank. Lebanese banks are part of the international banking system. It was, of course, save scenarios of money laundering and the sort. All international transfers in and out of Lebanon were done easily, done continuously, with no restrictions on amounts, origin, etc., except as the case may be in international marketing, international banking place. Next slide, please. What has happened also is that all of a sudden you had to transfer, you are a holder of a Lebanese bank account, and you had to transfer money either to yourself or to your kids who are getting some education abroad, or to your ailing family somewhere in the world, or to use the funds because these are your funds, and all of a sudden you cannot do this. This has been taking the shape of banks basically starting first to refuse execution of orders and instructions. So it has happened several times. You go to the bank, hello, please, I would like to transfer $1,000. They just say, sorry, we cannot, we have a problem, we have a technical glitch, etc. That's early 2020, mid 2020, there was a new way of dealing with these requests. So if you are asking for a transfer of your money, or asking, please, can I have all of my money transferred to where I live in France or in the UK, and the bank would basically close your bank account, trying to hand you a banking check, which is a check originally and supposedly needing to be cashed in Lebanon, but it cannot really be cashed in Lebanon. There were also closing of accounts and depositing of a banking check via notary public. Now, recently, the last things that we have seen, because of the developments that we will talk about with the court system, I have seen some banks trying to file a lawsuit against the depositor to declare the termination or the cancellation of the deposit agreement, and go and deposit these amounts and checks with the court. Of course, the checks is the big elephant in the room, because a check for this nominal value is not really a representative of this value. We will talk about this immediately. Next slide, please. So the checks have lost 85% of their nominal value. What does that mean technically? Is that if you are in dire need for some cash, and you have your money stuck in a Lebanese bank, if you draw a check for $10,000 currently today, plus or minus, you hand it to somebody working in the black market, and they will give you $1,500 in cash against the $10,000. This is a frequent practice. People who need fresh dollars or real dollars to do some business with have actually done this on multiple occasions. And of course, because of the market conditions, some people are willing to take those checks at those discounted rates for some other business of theirs. Now, of course, this has led to a complete meltdown in the number of checks cleared, checks used. Check today is not anymore a system that is being used to trade current funds other than Lebanese pounds with the devaluation, which makes it also a system that is not wanted currently by the market. Lately, most banks are no longer accepting checks, whether in USD or even in Lebanese pounds. Next slide, please. Now, also banks went commercially into unsound practices. We have seen some of them defaulting on risk mitigation. Banks should have been considered bankrupt or proceeded with restructuring long time ago. This has not been allowed till this day. There is not one single bank that has been declared bankrupt, and banks haven't been doing business almost as usual, with the caveat that they are not paying their dues, basically returning the money to the depositors. At that point in time, depositors had the choice, either stand idle or claim their rights. Next slide, please. Now, it is important to understand how it first worked. The initial mindset was that, and because of how we're structured in Lebanon, and most of the diaspora believed in the honest and transparent way the banking sector portrayed itself to be. So there was no legal recourse. It was not the first avenue. A lot of people try to find settlements to take certain discounts or just wait. And I could say today that according to recent statistics, around 80% of depositors in the Lebanese banking system till this day have not started legal action and have not recuperated their deposits. Now, after a first few months where people were just waiting to see what will happen, some people went into sorts of negotiations, settlements, whatever you can take out, just take it, discounts, finding people wanting to buy. A lot of real estate transactions have happened using checks, which is again using the Lollars that are stuck in the banks. And then we started to see more civil and commercial procedures, some of them on summary basis, some of them in Lebanon, some abroad. We have also seen some criminal procedures against certain banks for breach of bank secrecy law, which we will come on to quickly later on. And we have also seen interim and conservatory measures locally and internationally, leading to successful freezing orders that have been obtained in Lebanon and outside Lebanon. And I think that my colleague Rana will be addressing this issue a little bit later. Next slide, please. Now, in general, just so that you have an idea of what is the legal landscape in Lebanon, of course, there have been Lebanese banking laws. The founding law was a 1967 law, which is called the Law on Banking and Credit. And this is a law that is, though old, has been regularly updated, adapted to circumstances. The regulator, which is the Lebanese Central Bank, has been enacting a lot of measures on risk assessment, guarantees, corporate governance on the functioning of the banking sector, anti-money laundering processes, etc. You had in most banks several committees and subcommittees on risk, on employment, on placement, on credit, on investment, etc. The banks were looked at as mostly first-tier banks. Some of them were absolutely doing extremely well. Some of them were even listed on the Beirut Stock Exchange. And we saw, as of the 2000s, 2010, a lot of Lebanese banks buying assets outside, opening branches outside, or buying even banks in the region. You had several Lebanese banks having branches in France, in Switzerland, in the UAE, in Cairo, etc. Now, of course, the fact that the banks have observed their duty towards the depositors, some of them have till this day been trying to survive and doing, let's say, a not that bad of a job. Of course, you cannot let a bank pay all of the deposits at once. Otherwise, this would lead to a immediate collapse. So most other banks have not been doing this because of the high level of risk that they have been exposed to. And of course, on the consequential upshot, there's a systemic crash of the system currently, and depositors' legal standing is that they are entitled by law to have their deposit preserved and returned. And this is what I will be addressing in my next few slides. Next slide, please. Now, very quickly, Lebanon is a civil country, civil law country. So we have several articles of the law. I will not go through these, but it is important to just shed some light on the most important of these. Maybe we can go to the next slide for the viewers to see and keep up very quickly. So the very, very relevant articles of the law are as follows. So in our civil code, Article 690 says that the deposit is a contract by which the depository receives a movable thing from depositor with obligation to keep it and return it. Article 696 of the Civil Code also says that the depository must maintain the deposited thing within the same care that he would apply for the keeping of his own belongings. Article 700 of the Civil Code says that the depository is answerable for the loss of damage to the thing if he uses the trust deposit or disposes of it without the depositor's authorization. Coming to the Code of Commerce, you have to read this also in conjunction. Article 307 says that the bank which receives a deposit of a sum of money acquires ownership of the same, but it must return it on one or several equal payments upon the depositor's first request or pursuant to the deadline and notice conditions set forth in the contract. This is a very important part of the law that gives you the real definition. So if you deposit your money with a bank, the bank has to return equal payments, and we will talk about the value of this and how the Lebanese courts have been interpreting this. And most importantly, they have to repay them as per instructions received from the depositor. Next slide, please. This is a bit of the issues that have been there. So people, when they started asking the banks for their money, I will go quickly over the main defenses that were brought in by the banks and what was the position of the Lebanese courts on those allegations. The first and most of all, because obviously here you are not in a situation where you are debating how much you have in deposits with the bank. Most of the times you have a bank statement that says that you have $10,000 in a bank account. You go to the bank, you say, hi, I want my money. They will know absolutely no problem. Here is your check. Now, there has been an issue about whether this is the real value of the money that you have deposited. Of course it's not, because if you take the check, you cannot get $10,000 for that check. You will get something else. And this is the core of the issue. Now, Article 7 and 8 of the Code of Money and Credit has on the one hand, imposed unlimited exonerating effect to the Lebanese pound, which means, and this is like every other country in the world, local currency should serve as a basis to exonerate yourself from obligations. But at which rate? Because this is where comes the trick, is that banks have tried to repay money deposited in US dollars in Lebanese lira at either the official rate of 1,500 when the rate is way above, which means with a devaluation, or at any other rate that is not the real rate of the deposit or of the US dollar vis-a-vis the Lebanese lira. Now, this has led to the actual dispute. Of course, Lebanese courts, when confronted with this issue, have specifically and not long ago, because it took some time, I would have to admit that we have had some difficulties specifically through the Corona times. So in 2020, after which there was a very big explosion in Beirut in August 2020, there was delays in the functioning of the Lebanese courts. But what we have seen is that as of mid-2021, quarter 4, 3 and 4 of 2021, Lebanese courts and judges have started to understand, finally, because it was almost unthinkable that somebody comes and says, hi, I don't owe you any money because I have this check for you, which has a nominal value, but it does not represent the same value. And recent court decisions have been conclusive on this point. Everybody knows today that the check does not represent the real value. So the real value is either if you can prove that this is in a banknote, or if it is, and it is always a foreign currency, if you can get it through the international banking system, i.e. you can transfer it. So if I have this $10,000 in the bank, the only proof for me that the money exists is that either it is given to me in cash, or I can transfer it freely to my bank account anywhere in the world. This is the core of the issue, and Lebanese courts have been quite clear on it. Now, another response by the banks was that at the moment or the minute you ask for the transfer of your funds or your deposits or anything of the sort, they immediately go and they terminate your account opening agreement, which is a unilateral right. Most banks have the right to do that, usually for good reasons. So unless there is a criminal process behind having a bank account, or maybe this is a bank account that is a debit in a debit mode, you're not paying your dues, you have an excess of it, they cannot really close the account. The Lebanese court and the judges in Lebanon have been very clear on that in application of this famous principle of good faith performance of obligations and contracts. Lebanese courts have found that the unauthorized and unjustified termination of an account opening agreement is illegal. It is reversible by the court. So they have ordered the banks to reopen those bank accounts, and they have, of course, inflicted damages on the bank for unilaterally terminating in bad faith the account opening agreement, only to evade their obligations to repay the deposits. The next slide, please. Now, on the checks deposited before notary public, so just to explain the situation, it has been something that is usually used when somebody has a debt and the creditor is not accepting to be paid for some reason, etc. There is a procedure quite well known in most of civil law countries, where you go and you do a deposit before a notary public. So you present a check, and this check is usually a banker's check, and this banker's check means that there is a confirmed amount in that check, and you put it with the notary public, asking the notary public to inform the counterpart of the existence of this check, and this may be one way of exonerating yourself of your obligation. So what has happened is that Lebanese banks started to issue bankers' checks in the name of their depositors, have those checks even stamped by the regulator, i.e. by the Central Bank of Lebanon, and deposited with notary publics, alleging that this is enough to clear them from their obligation to pay back the deposits. Well, Lebanese courts, amazingly, again, found that this is, of course, an unacceptable way of payment, even though a check is usually understood as a payment method and an actual payment of funds. If it does not represent the real value of the amounts owed, then the whole use of this process is faulted. And accordingly, in several cases where Lebanese banks have done this practice, the courts have said, no, we will not accept this as a way of exonerating the bank. On international transfers, this is another big thing. I have seen several banks saying, sorry, and by the way, we don't have an obligation to do an international transfer, because nowhere in the contract and in the account opening contract or agreement do we have an obligation of the sort. The Lebanese court system has also clarified its position and has said, we're sorry, but for years, the Lebanese banking system has been advertising and putting in front of everybody that they have the ability to receive and send money inside and outside. Most of the USD deposits came from outside Lebanon. Euro deposits came from outside Lebanon. Otherwise, how can it come? So the obligation to do an international transfer is real. Unless there is something in the contract that allows the bank not to do it, it should be assumed. And this is something that is a very big victory against this allegation and defense raised by the Lebanese banks. One further defense we have seen is that the banks have started to say that if they pay those deposits back, the Lebanese banking system will collapse, as if it has not already collapsed. So, but this has been refused, because this is not a theory that you can work on. It is not force majeure. It is totally within the prediction of any Lebanese bank that was properly operating and using the system. They should have known that something like this can happen, and they should have been ready. And therefore, the decision to deposit and to lend these huge amounts of money internally to the Lebanese government and to the Central Bank of Lebanon has led to something like this. And this was not concerted and not agreed by all the depositors. So this is a very clear case for the depositor to say, sorry, this is your problem. Our problem is that we trusted in you so that you keep our money, because the real role of a bank is to keep the money, not dissipate it. Now, basically, these are the main things that I wanted to discuss with you today in terms of what are the recent findings by the Lebanese courts. We strongly believe that the Lebanese judiciary has been more and more getting hands on those issues and defining properly the rights of the depositors. This is not without certain risks, including certain risks on the judiciary system in itself. Today, the judiciary is in a state of strike in Lebanon, so courts are not operating properly because of the financial pressures on the judges, on the ability to do their job, on the supply of electricity, part of the overall economic and financial crisis that Lebanon is going through. Now, there might be other issues to be considered. A capital control law has been requested for a very long time by the International Monetary Fund, by the World Bank, by whoever's trying to assess the situation. This may affect eventually the status of those deposits, at least for the time being. However, we have also seen some very successful scenarios where banks were one way or another forced to execute and basically accept client instructions to take the money out of the Lebanese banking system. So this is quickly what I wanted to discuss. I will now hand over to Rana to tell us a bit more about precautionary measures and seizures done inside and outside Lebanon. Thank you.
Thank you, Muhammad. So basically, when the depositor chooses not to remain idle and to sue the bank, the first step that must be taken is not to sue the bank, but rather to ensure the respondent or the prospective respondent bank has assets that are sufficient to satisfy the potential claim in the event a favorable award or a favorable decision is issued for the depositor. So basically, asset tracing should be the necessary first step in securing the claim. Aaron, could you please move to the first slide? So what is asset tracing? It is the process of locating financial assets, property, or other valuables through a formal search. Usually, asset tracing is conducted through specialized firms. Some investigators have a specific job to look for assets of a particular entity or a particular person, or even we can resort to official registries in order to locate assets, the assets of our respondent. For instance, in Lebanon, the land registry can provide an exhaustive list of all real estate assets owned by a given entity or a given person, in these instances of the bank, which we are intending to sue. Once assets are traced and we are satisfied that the value of these assets can guarantee or are sufficient to enforce a prospective favorable award, we can move to the next step. The next step is usually the filing of a lawsuit. With the filing of a lawsuit, a necessary step is to file for precautionary seizure. What is a precautionary seizure? A precautionary seizure is a procedure by virtue of which we seek to freeze a debtor's assets in order to recover them when the creditor has obtained an enforceable award or an enforceable order. Precautionary seizures or freezing orders for the Anglo-Saxon audience are not standalone procedures. They must be correlated to a substantive claim or a claim on the merits, because their purpose is actually to guarantee the enforcement order which is obtained when the claim is asserted. The motion of precautionary seizure must therefore be related to a substantive claim, but it can be filed either before a substantive claim is made before the competent court or after such substantive claim is made. Now, in the context of this feud between the depositors and the Lebanese banks, many precautionary seizures have been asserted inside Lebanon and outside Lebanon. Inside Lebanon, those seizures affect the assets of the banks located in Lebanon. Next slide, please, Aaron. Aaron, next slide. So to continue, in Lebanon, all assets owned by the bank can be seized except those enumerated by Article 860 of the Lebanese Code of Civil Procedures. And there's a particularity of the Lebanese system which attaches to the bank secrecy law, pursuant to which bank accounts cannot be traced and therefore they cannot be seized. And this is something obviously that is a downside and that reduces the asset base for the depositor, and it reduces the guarantees of the depositors. The procedure to follow in order to assert precautionary seizures in Lebanon is quite straightforward. basically the petitioner must submit a motion for precautionary seizure before the president of the execution department of the bank's place of incorporation or place of business. The procedure is non-adversarial, which means that the judge would issue its decision, or his or her decision, sorry, on the basis of the documents submitted to it by the petitioner without hearing the opponent, the bank, which makes for a fast-track procedure. And normally, put aside the judiciary strike, the current judiciary strike, a decision or an order is usually issued within a couple of weeks. The standard of proof that is required is relatively low in Lebanon, because what is sufficient is to demonstrate that the debt is likely to exist. So it is the likelihood of the debt that must be proven by the petitioner. In Lebanon, and as mentioned earlier, the lawsuit on the merits or the substantive claim must be made with the competent court either before the precautionary seizure motion is filed or maximum 5 days after a freezing order is issued and notified to the opponent party. We have seen encouraging outcomes in Lebanon when it comes to precautionary seizures. Several execution judges have actually issued freezing orders against banks' assets, but we are yet to see whether these orders will be translated into executory orders once a final decision on the merits is issued. Now, there's a next slide, please, Aaron. There's a particularity when we speak of bank and when we speak of precautionary seizure on banks' assets, which attaches to the bank's legal reserves. As many of you may know, the Central Bank of Lebanon imposes on banks reserve requirements on assets and or loans that these banks own. And this is pursuant to Article 76D of the Code of Money and Credit. Those reserves are actually monies deposited with the bank, which the bank must deposit with the central bank in Lebanese pound or in foreign currencies, including in real US dollars. It was found that legal reserves remain the property of the bank, of the commercial bank, and therefore they remain part of the bank's assets, which means that they may be capable of being seized. And in fact, many depositors have sought twice to request seizure on the bank's legal reserves with the central bank. This is what you call a third-party seizure, because like the money is deposited with the third party, in these instances, the Central Bank of Lebanon. There were conflicting decisions from the judiciary in these regards. Some execution judges have accepted to issue freezing orders on the bank's legal reserves, others have not. Those who have chosen not to issue these orders argued that, or they rejected the petitions on the premise that legal reserves are subject to bank secrecy, or that those legal reserves, it is not judicious to issue freezing orders on these reserves because they were being used by, or they are still used by the central bank to boost the economy, whether through subsidizing goods or whether through feeding the Sayrafa platform. What is sure though is that the debate or the discussion on this issue is not conclusive, and you are yet to see in any event whether the central bank will cooperate in implementing these freezing orders. Next slide, Aaron. In what pertains to precautionary seizures outside Lebanon, well, it is very likely that Lebanese banks own assets outside Lebanon, and in respect of these assets, depositors may seek precautionary seizures in the jurisdiction where these assets are located. Generally speaking, we have found from several case precedents or from the cases that were exposed to us and to other firms that bank assets abroad encompass real estate. But here we have to caution the depositor that in the face of the proliferating foreign precautionary seizures measures, banks have started transferring the ownership of their foreign assets to either to their shareholders or to other companies created for these purposes in order to just exclude them from the asset base and shield them against any possible freezing order. So basically, there's real estate. There are also shares in foreign companies owned by the Lebanese banks. These shares are mostly shares in the foreign subsidiaries of the Lebanese banks. Those also are assets that can be seized. And finally, and this is a distinction with the Lebanese system, in many jurisdictions, there is no bank secrecy legislation, and therefore the accounts owned by Lebanese banks abroad can be seized. We have seen in many instances freezing orders on the Lebanese current accounts and associated companies, and with intermediary banks. The procedure for a foreign precautionary seizure is different from country to country. The rules are generally different. The standard of proof is different. However, the main feature which we have addressed when speaking of precautionary seizures in Lebanon remains. So as we said, the precautionary seizure is not a standalone procedure. It must correlate to a substantive claim. However, the foreign judge accepts that this substantive claim, that the case filed in Lebanon, the substantive case filed in Lebanon, can constitute a valid ground for a precautionary seizure outside Lebanon. This means that if we are to seize the foreign bank assets, we do not have to necessarily file a claim in the foreign jurisdiction in France or in the UK, etc. There were encouraging outcomes also abroad. Many freezing orders were reached abroad. They were issued abroad. And obviously, the possibility for the depositor to reach and to trace and freeze the bank assets abroad is certainly an upside for the depositor in securing its claim in this feud against the banks. Now I turn to my colleague Nicholas Che to address the foreign solutions, and notably in the UK.
Thank you very much, Rana. So there have been 4 notable cases which have arisen before the English courts in respect of the Lebanese banking situation in recent years. I'll discuss each of them briefly, but this really boils down to what I would say is a tale of 2 cases, and that is the Khalifa case and the Manouchian case. Now, the first case in time, which came before the English courts, really was limited to a question of jurisdiction only, and that's the Bitar case, which you see at the top of this first slide. Aaron, can you move to the next slide, please? So the important point in the first Bitar case is simply that the English courts found that they can accept jurisdiction over a foreign law governed consumer contract under an exception which exists under sections 15A to E of the Civil Jurisdiction and Judgments Act of 1982. Now, that act provides the consumer may bring proceedings against the other party to the consumer contract in the courts for the place where the consumer is domiciled. Now, in considering whether they would accept jurisdiction over the case, this first Bitar case and claim, the English judge had to decide whether the Lebanese banks in question had directed their commercial activities towards England. Now, as you may know, under European EC, that is law, this question of direct to was dealt with by the Court of Justice of the European Community in its decision concerning cases C58508, that's PAMA, and C14409, the Hotel Alpenhof. Nowadays, and given electronic commerce is enabled by the internet, it's not necessary as a matter of English law for a consumer claimant of a foreign bank to show that the bank has any physical branch in England. So no physical place of business required in England. Nor is it necessary to show that there is a subjective intention on the part of the bank to direct its business to England. Those are the conclusions in respect of jurisdiction and why jurisdiction has been accepted by the English courts in respect of consumer depositors of Lebanese banks who may be resident in or have resident in England or have British passports. Now, my senior partner Mohammed Alam has already mentioned Article 822 of the Lebanese Code of Procedure. Can we move on, please, Aaron, to the next slide? So, in the Khalifa case, Blom Bank won a victory for the Lebanese banks. They went 1-0 up at half time because in that case, despite what Mohammed said about Article 822, which is of course the correct Lebanese law interpretation and application of that procedure, and where it poses great difficulties if a bank does not give real value to a depositor. In the case that Mr. Khalife brought before the English courts, it was not argued by him, and this was found by the judge, Mr. Justice Foxon, at paragraph 136 of the judgment. He said, Mr. Khalife does not contend that a bank which holds a foreign currency deposit account is obliged to effect an international foreign currency transfer at the customer's request, and to that extent does not seek to support the reasoning in the summary procedure cases which have made that finding. So unfortunately for that depositor in the Khalife case, the courts found against him because he appeared to have accepted that no international transfer right existed as a matter of Lebanese law or of his particular banking contract with Blom. Can we move on now, Aaron, please, to the next slide? The Mnookin case, though, followed the Khalife case in time, and it led to a drastically different outcome. In fact, interestingly, and very shortly after the Khalife decision was issued, the two defendant banks in the Mnookin case sought to invoke the tender and deposit procedure pursuant to Article 822. And that was unsuccessful in this case. Now, why was that? Because in the Mnookin case, unlike in the Blom case, the depositor had actually claimed that the banks had an obligation to make international transfers. Now, Mr. Justice Pickett, hearing the Mnookin case, found that Lebanese law applied as per the terms of the relevant consumer banking contracts, and that was at paragraph 42 of the judgment. The learned judge then applied Lebanese law in finding that ambiguous clauses should be construed in favor of the consumer depositor per Article 18 of the Lebanese Consumer Protection Law. And applying these principles of law and interpretation, the English court found that there did exist a contractual right on the part of the consumer depositor to require international transfers by depository bank. And the judge further found, and this is at paragraphs 86 and 93 of the judgment, that a contractual obligation did exist in the particular contract as a result, this is an implied obligation, of custom and practice applied by the banks in offering transfer services to their clients. However, the judge did refuse to make any final determination or finding as to whether there existed any general rule under Lebanese law in respect of a general right for consumer depositors to require international transfers. So the net result, which is at paragraph 130 of the judgment in Mnookin, is the judge found that Mr. Mnookin was entitled to claim specific performance of the international transfer which he'd been requesting. And permission to appeal, although requested by the bank, was refused. Next slide, please, Aaron. The only thing that you really need to know about the Bitar against Beirut Bank SAL case is that it largely confirms the findings in Mnookin. Again, there was a careful analysis of the contracts and the factual matrix of that case by the judge, and it was found, as is customary in common law, that of course each case is to be assessed on its own facts. What happened after the Mnookin case in Lebanon was that in early March 2022, only a few days after the order had been made, there were press reports emerging that Bank Audi had already closed, in fact, more than 30 accounts held by British passport holders who might also have Lebanese nationality. and whether or not these people were in fact resident in the UK or not. So there are press reports which have circulated in Lebanon, which tend to suggest that Lebanese banks are now asking depositors to agree to new terms and conditions whereby the depositor accept that there will be no international transfers, no cash withdrawal, and where exclusive jurisdiction is afforded to the courts of Beirut. And apparently, according to the press, where these new terms have been refused by customers of the banks, then Lebanese banks have then proceeded to close accounts and seek to issue checks for the account balance at the notary public and deposit them pursuant to Article 822 of the Lebanese Code of Civil Procedure. That concludes what I have to say, so I pass the baton to my learned colleague Mazen Gurn.
Thank you, Nick, and good afternoon to everyone following this webinar. For the next 5 to 7 minutes or so, and I do hope I will not be held liable for any potential overrun, I will be addressing in brief the issue of recourses available to holders of Lebanese sovereign bonds. Now, one might ask, what is the connection between depositors of Lebanese banks, which is the main theme of this webinar, and bondholders? And the answer to this simply is that bank depositors in Lebanon are, for the overwhelming majority, either directly or indirectly holders of sovereign bonds. That is because, as of the late 90s, the Lebanese banking system started shifting away from using collected deposits towards boosting different sectors of the economy, which is supposed to be their main function, to simply funding the Lebanese public debt. And in what had effectively turned into an economy of rent, Lebanese banks endeavored over the past 2 decades to convince their depositors to invest in sovereign bonds against increasing interest rates. Now, in this first slide, I briefly describe the history of Lebanese sovereign bonds. It is quite recent, relatively speaking. It essentially started in and around 1993 through the issuance of treasury bills, which were mainly aimed at financing the reconstruction of the country after the civil war. Now, between the end of the 90s and until 2019, treasury bills were gradually replaced with government bonds, which had longer maturities and were issued in foreign currencies, specifically in US dollar. These government bonds are now known as Euro bonds. And I should note here that the term euro in Eurobond is meant to imply external, as in external bond, and has no particular connection to Europe or the euro currency. In fact, the term Eurobond has been in use since the 60s, way before the advent of the euro currency, which occurred in 99. So, what is a Eurobond? It is a debt instrument issued by private organizations, international syndicates, and relevant to our discussion today, governments in need of foreign denominated money. Eurobonds usually generate fixed interest rates, often payable on a quarterly basis, and they are called bonds. Also on this slide, you can see a very quick depiction of the current state of Eurobonds as they stand, the outstanding Lebanese Eurobonds. They relate to 29 series that were issued by the Lebanese government between April 2006 and November 2019, with maturities varying between March 2020 and March 2037. The face or nominal value in total of these outstanding Eurobonds is about 31.3 billion US dollar, whereas their actual value on the secondary market is about 1.8 billion US dollar. This, of course, represents about 6% of the bond's face value. The reason, you might ask, behind this extremely low market value for outstanding Eurobonds is that Lebanon has defaulted on the payment of 1.2 billion US dollar of bonds, which had matured back in March 2020. And this was indeed the first time that Lebanon defaulted on its public debt. Now, pertinently, for the purpose of our brief discussion today, it is estimated that about 38.7% of the outstanding Lebanese Eurobonds are owned by foreign creditors. Can we perhaps turn to the next slide, please? Now, in this coming slide, I briefly tackle the key relevant contractual mechanisms contained in Lebanese Eurobonds. Two very quick remarks here. Lebanese Eurobonds in general contain what is known as a cross-default provision. The main effect of such provision is that in case of default under one series, in our case, for instance, the series that matured in March 2020, this has the effect of triggering the default under all outstanding series, i.e. Eurobond outstanding series, of course, if they haven't reached maturity at the time of the default event, or even if they haven't reached maturity at the time of the event. Now, another relevant feature of the Lebanese Eurobond is that they're generally governed by the laws of the state of New York, and they provide for the non-exclusive jurisdiction of New York courts, which gets me to the main issue covered in this section of our webinar. What are the recourses available to holders of Eurobonds, and why should one avenue be preferred over others? I should preface my answer by referring to Article 860, paragraph 1 of the Lebanese new Code of Civil Procedure, which, having been enacted in 1983, is not so new anymore. Now, Article 860, paragraph 1, expressly prohibits enforcement against all assets owned by the state or by any other public legal person. This, coupled with the fact that the Lebanese state does not own a lot of assets outside the Lebanese territory against which enforcement may be possible, had the effect of dissuading bondholders from pursuing legal actions against Lebanon following the default event of March 2020. Next slide, please. Now, luckily for non-Lebanese holders of Eurobonds, other legal avenues exist and may be more efficient than commencing legal proceedings before state courts. And I'm, of course, talking about investment arbitration. Investment arbitration, in brief, is a procedure to resolve disputes between foreign investors and host states. In order to prevail in an investment arbitration against a defaulting state, a bondholder needs to demonstrate three things. One, that they qualify as foreign investors under the relevant instrument or treaty. Two, that their purchase of Lebanese sovereign bonds qualifies as protected investment. And three, that the sovereign default amounts to a failure by the respondent state, Lebanon in the present case, to abide by its international obligations to protect foreign investments made on its territory. Now, it transpires from recent awards rendered by investment arbitration tribunals that the main stumbling block revolves around whether or not the purchase of sovereign bonds qualify as a foreign investment made in the defaulting state within, of course, the terms used in the applicable instrument or treaty. Now, although this qualification is yet to be unanimously upheld in international arbitration practice, an increasing number of decisions have ruled in favor of qualifying the purchase of bonds as a foreign investment that should be protected in the host state, similarly to any other recognized foreign investment. Over the past 2 decades, numerous arbitral proceedings were initiated by foreign bondholders against defaulting states such as Argentina, Venezuela, and more recently, Greece and Cyprus. Some of these arbitrations involved several thousand bondholders who were regrouped as claimants in what could be regarded as class action proceedings. And these are, of course, key features which can be found in an investment dispute opposing bondholders to defaulting states. Perhaps very quickly, a few words on the standards of protection that are generally afforded to foreign investors under international investment law. Relevantly for our discussion today, two main standards of protection come to mind. These are the fair and equitable treatment, also known as the FET standard, and also the expropriation, protection against expropriation. On the first point, the FET standard, it effectively requires the host state to provide treatment that does not affect the basic expectations that were taken into account by the foreign investor when making the investment, i.e. when purchasing the sovereign bond. Now, worthy of noting that in general, arbitral tribunals tend to consider that a simple breach of contract would not amount to a breach of the FET standard. Pertinently, for our discussion, in the specific case of sovereign default, of particular relevance is how the state conducts itself in restructuring processes whether before or after the default. Now, in the case of Lebanese sovereign bonds, such restructuring processes are usually governed by a specific provision known as collective action clause. On the expropriation, well, expropriation in brief is one of the most serious ways to obstruct the use of property. It destroys all expectations of the investor, particularly when no compensation is provided when the investment is seized. Such protection is usually extended to both tangible and intangible rights, and therefore includes contractual rights which may arise from sovereign bonds. Few concluding words perhaps on ICSID as a forum of choice. Now, there are of course several international instruments that provide protection to foreign investors. The most widely used instrument arises from the Washington Convention on the Settlement of Investment Disputes, which is also known as the ICSID Convention. Adherence of state to the ICSID Convention is generally coupled with bilateral investment treaties, also known as BITs, and these are entered into between two contracting states of the ICSID Convention, so it comes at a later stage. In our case, Lebanon is party to 50 BITs, of which 42 are in force. These BITs are also supplemented by multilateral treaties, such as the Organization of Islamic Cooperation Agreement, also known as the OIC Agreement, and the Arab Investment Agreement. Each of these agreements, of course, and treaties provide various protections and guarantees for foreign investments and grant foreign investors access to some of the investor-state dispute resolution mechanisms that are available. Now, thanks to the substantive protections and the forum selection choices included in BITs, the BIT framework gives bondholders an alternative forum, an alternative one that has been preferred in some occasions over the option of resorting to national courts. And the reason for that is that compliance of states with, for instance, ICSID awards has been relatively high. That's because of reputational risk, pressure from the World Bank, as well as diplomatic and political pressure to pay the award when it is rendered in favor of investors. So in summary, and in light of the very limited number of assets owned by Lebanon against which enforcement may be possible, it is highly likely that the non-Lebanese bondholders may resort to ICSID arbitration or any other form of investment disputes against the defaulting Lebanese state in the near future. And such actions and proceedings are likely to have chances of success and may be promising to the potential claimants. This concludes my section. Thank you very much for your attention.
Great. Well, thank you all. I will now revert back to Dan. Maybe we could take one or two questions. Dan?
Thank you very much, Mohammed. And I just want to say thank you very much to the panel, and I apologize for going slightly over time. Judging by the vast number of you that have stayed with us, I'm sure you all appreciated the presentations. We will have to limit the Q&A, I think, to one question, Mohammed, if that's okay. And I have a question in from the audience. Are foreign banks operating in Lebanon allowed to evacuate funds?
There are basically no restrictions till this day to evacuate funds from a legal standpoint. So effectively, whether you are a foreign bank or a local bank, because there are no differentiation historically and legally in Lebanon between foreign banks established in Lebanon and Lebanese banks established in Lebanon. So there are no restrictions. Whether you had money with let's say HSBC, but HSBC had winded up a few years before the crash. Same for Standard Chartered Bank, BNP Paribas, etc. There were very few left, probably amongst which is one of the very large regional banks called the Arab Bank, which headquarters are not in Lebanon, and which is basically allowing itself and the clients to do operations let's say, more or less normally within the restrictions of the Lebanese rules and regulations, specifically those enacted by the Lebanese Central Bank.
Excellent. Thank you very much for that answer, Mohammed. We have had some great questions in today. If we didn't have time to get to your question, we will be sending them on to the panel, but I do encourage you to get in touch, and anybody that needs any information and help, we do encourage you to get in touch with the panel. We will circulate a follow-up tomorrow with their contact information, so please do get in touch. So thank you again to our wonderful panel for their insights today. It's been a really fascinating session, and thank you to you for being with us. I hope we can see you all again soon. But for now, have a lovely rest of your day. Goodbye.